Welcome to Real Estate School. Today we're bringing you several important terms and definitions we think that you need to know to pass your state's licensing exam. So if you like what you hear, subscribe below and ring that bell, and we'll keep you up to date with our future videos. Thank you. Appurtenance is a right or privilege associated with the property, although not necessarily a physical part of it. Examples of appurtenances: parking spaces in multi-unit buildings. You own a condominium and you own 2 parking spaces in the parking garage along with the condominium. Behind the condominium building is a group of boat docks on the water. And if you own one of the condominiums, you own one of the boat docks. The boat dock is an appurtenance. It's a separate piece of real estate, but it's tied to ownership of the condominium. The key is there's language written into the deed that says part of ownership of this property is the ownership of that boat dock or those parking spaces. So if the property is transferred, the appurtenance would transfer along with it. Liens. A lien is a charge against property that provides security for a debt or an obligation of the property owner. If the obligation is not repaid, the lien holder is entitled to have the debt satisfied from the proceeds of a court-ordered or forced sale of the debtor's property. Liens are an encumbrance on the owner's title. They're attached to ownership. If the property is transferred without the lien being paid off, the lien transfers with ownership. Deed. A deed is a document by which an owner of real estate conveys the right, title, or interest owned in the parcel of real estate to someone else. A deed is a custom-written document. It names the buyer, the grantee. However, a deed is only signed by the seller, the grantor. Priority. Priority refers to the order in which documents or liens were recorded. A lien's priority is based on the date the lien was recorded in the records of the county or city where the property is located. Agent. The individual who is authorized and consents to represent the interest of another person in dealing with a third person. In a real estate transaction, the broker is the agent of the client and may share this responsibility with the agents who work at the firm. Principal. The individual who hires the agent and delegates to that agent the responsibility of representing the principal's interest. Customer. The third party or non-represented consumer who is not a principal, but for whom some level of service may be provided and is entitled to fairness and honesty. The customer is the unrepresented third party. Consideration. Something of legal value offered by one party and accepted by another as an inducement to perform or refrain from performing some act. Courts do not inquire into the adequacy of consideration. The only requirement are the parties agree and that no undue influence or fraud has occurred. An easement. Simply, an easement is the right to use somebody else's land. That use could be in the airspace, it could be in the surface, or it could be in the subsurface. Normally, there's 2 parties involved with an easement: the dominant tenement and the servient tenement. The servient tenement serves by providing access across their property for the dominant to use. The dominant tenement controls the easement. Three important terms to be familiar with for your real estate exam: land, real estate, and real property. Three terms that sound a lot alike, but there are subtle differences, and it's important to know the differences in the meanings. Land, when you think of land, think of all the natural components, the dirt, the trees, the boulders. And second, when you think of land, think three-dimensional. Land includes the surface, but it also includes the airspace above the land and the mineral rights that exist below the land, the subsurface rights. Real estate. The difference between land and real estate is land plus all human-made improvements to the land. Anything man-made is considered an improvement to the land. Real estate is land plus improvements. And the third term, real property, the broadest term of the three. Real property is land plus improvements plus the legal rights that go along with owning land. Think of air rights, legal rights of ownership. Fixture. When you hear the term fixture, don't overthink it. This could be simply a light fixture. A fixture starts off as personal property, but has been attached to the home in such a way that it becomes part of the home, or real property. Examples could be kitchen cabinetry, light fixtures, ceiling fans. You buy lumber and build a deck on the back of your house that has now been attached to the home and has become a fixture. Personal property. Personal property is movable. A good way to think about personal property, if you could pick up a house, turn it upside down, and shake it, the things that aren't attached and are going to fall out of the house, usually those are personal property items. The refrigerator, the stove in the kitchen, if the old slide in the countertop stove, cooktop range. On the other hand, if the range is built into the wall, that's part of the home, real property, it's attached. Trade fixtures. By putting the word trade in front of fixtures, it changes the meaning of fixtures. Trade fixtures are fixtures used in the course of business. Glass cabinetry installed in a retail shop, dining booths in a restaurant, or maybe even the kitchen equipment. When we think of trade fixtures are personal property of the tenant. If the tenant leaves them in the property beyond the terms of the lease, they then become real property of the landlord. Fee simple absolute. One who has ownership rights that could continue forever, and that no other person can claim to be the owner of or have ownership control of the land. Fee simple absolute is the highest form of ownership recognized by law. And if you own a home, I would imagine you have fee simple absolute ownership, as opposed to fee simple to feasible. Fee simple to feasible is ownership that comes on a condition. If you use the land for this, you can lose ownership. Life estate. A life estate is ownership. Ownership limited in duration to either the life of the holder of the estate or the lives of some other designated person or persons. Legal life estate. A legal life estate is ownership interests that are granted by law. The right to inherit your spouse's property. Easement by prescription. If a claimant has made use of another's land for a certain period of time as defined by state law, an easement by prescription or a prescriptive easement may be acquired. The most common example is your neighbor installs a fence around their backyard. By mistake, they cross over 6 inches onto your property. You realize the fence is on your property, but you don't say anything about it. You just let it go. After 20 years, you can't make them move that fence. You still own the land. It's just you've allowed them to use your land for a long enough period of time. You can't stop their use of the land. Easement by prescription. License. A license is permission to enter the land of another for a specific purpose. A license can be terminated or canceled by the owner of the property. If the right to use another's property is given orally or informally, it is generally considered to be a license rather than an easement. Encroachment. When a building, fence, or driveway illegally extends beyond the boundaries of the land of its owner or legal building lines, an encroachment occurs. Your neighbor puts up a shed. By mistake, they've crossed 2 feet over onto your property. Your neighbor is encroaching onto your property. An encroachment can lead to an easement by prescription if the encroachment is allowed to continue for a number of years based on state law. Eminent domain. Eminent domain is the right of the government to acquire privately owned real estate for public use. On your exam, look out for questions referring to eminent domain that uses the term process. What is the process the government uses to perform eminent domain? In that case, the answer is condemnation. Condemnation is the process by which the government exercises its right of eminent domain. Escheat is a process by which the state may acquire privately owned real or personal property. Ownership of real estate can escheat to the state when an owner dies and leaves no heirs, and there is no will or living trust instrument directs how the real estate is to be distributed. Ownership and severalty. Severalty is derived from the word severed, or cut off from other owners. Ownership and severalty occurs when property is owned by a single individual or a corporation. Concurrent ownership. When title to real estate is held by 2 or more individuals, those parties are called concurrent owners or co-owners. Tenancy in common. One of the more popular forms of co-ownership. If you and I are to buy a house together, we'd more than likely take ownership as tenancy in common. In tenancy in common, we can have unequal amounts of ownership. You have 70%, I have 30%. That would have to be stated in the deed. The secret, though, when one of the co-owners passes away, they're able to will their interest to whoever they desire, pass their ownership on through their will. As opposed to joint tenancy, another form of co-ownership. The unique feature of joint tenancy is always the rights of survivorship. That wording is written into the deed. Ownership with rights of survivorship. And what that means is when one of the co-owners passes away, their ownership interest transfers to the other co-owners. In a sense, there's one less owner that owns the whole. If you do ever get the question, what is the main difference between tenancy in common and joint tenancy? The disposition of one person's interest upon death. What happens to their interest after they pass away? General warranty deed. The most common type of deed used in a real estate transaction. A general warranty deed provides the greatest protection to the buyer because the grantor, the seller, is bound by certain covenants or warranties. A general warranty deed provides the most warranties to the purchaser from the seller. Promises. If this happens after closing, I'll make that good. Adverse possession. Adverse possession is a means of involuntary alienation or transfer of ownership. An individual who makes a claim to certain property takes possession of it by excluding the owner and other claimants, and most important, uses the property, may take title away from an owner who fails to use or inspect the property for a period of years based on state law. Abstractor. Abstractor is a profession. This is the individual or business that is hired by the attorney or title company performing the closing. The abstractor goes down to the city and searches all the areas of public record and puts a report together called an abstract of title that is returned to the attorney or title company doing the closing. The title company or attorney reviews the abstract of title, and if they like what they see, issues either a certificate of title or an attorney's opinion of title. Marketable title. Title that is acceptable to a reasonably prudent person and which would not subject the buyer to litigation. To be marketable, a title must convince a reasonably well-informed and prudent purchaser that the property they're purchasing could be sold or mortgaged at a later time in the future. Title insurance. Title insurance insures a purchaser from the unknown, things that could not be discovered from a search of the public records. There are two types of title insurance: lender's title insurance and owner's title insurance. Lender's is required. If you're getting a mortgage loan, you have to purchase lender's title insurance. Lender's title insurance protects the lender by insuring the balance of the loan. As the loan is being paid down, lender's title insurance is decreasing. Eventually, you've sold your home or you've paid off your loan and you no longer have title insurance protection. Owner's title insurance, which is an option. Most people purchase it, but it is an option. Owner's title insurance protects the owner for the purchase price of the home for the rest of their life and their heirs. So the different types of policies depends on who's named as the insured.